Good afternoon, distinguished participants. Thank you for joining us virtually and in person. Welcome to the first afternoon session. I'll hand over to Justin Agbeli, Amenuvor, the moderator for the session. Thank you.
Good afternoon, ladies and gentlemen. Our topic for this afternoon's first session is social media and ethics. Where do we draw the line? Now, to help us try and draw the line are two distinguished speakers. Justice Nene Amegatcher, Justice of the Supreme Court, holds a Master's of Law degree in Advanced Litigation and Dispute Resolution from the Nottingham Trent Law School, the UK. He was called to the bar in 1980 and rose to become a notary public and managing partner in the law firm of Sam Okudzeto and Associates. He has also served as an adjunct lecturer in ADL, Advocacy and Legal Ethics at the Ghana School of Law. Justice Amegatcher is a past president of the Ghana Bar Association, a past council member of the Commonwealth Lawyers Association, and many others. Second is Victoria Barth, and she is the current managing partner and head of dispute resolution and litigation at Sam Okudzeto and Associates. It's a leading law firm in Ghana. She teaches advocacy and legal ethics at the Ghana School of Law and also chairs the Ethics and Compliance Committee of the Prudential Bank Ghana in her capacity as a non-executive director. Without much ado, let me invite His Lordship, Justice Nene Amegatcher, to take over.
Good afternoon, and thank you, Justin, for your kind introduction. For those of you who do not know, Justin was my national secretary when I was president of the Ghana Bar Association. Of late, he's been avoiding me. I don't know the reasons, but it's good we have met here. We are dealing with the topic, as he said, social media and ethics. Where do we draw the line? I was wondering why lawyers should be asked to study a topic like this or discuss a topic like this. It is because the profession is one of the most regulatory or regulated profession in this world. And you cannot do anything you like. Everybody is on social media. Nobody complains why people are on social media. But for lawyers who are on social media, there's the need for the profession to discuss it and direct and guide them so that they do the proper thing. And that is why we are here discussing this topic. Of course, we know what ethics is. These are guidelines given to lawyers and judges in order to regulate their activities so that the profession we all belong to, we will safeguard its reputation and inspire confidence among the people. So one of the reasons why we are discussing this topic is that judges and lawyers, according to our rules, shall at all times maintain the honor and dignity of their profession or calling as essential agents of the administration of justice. So whatever judges do, whatever lawyers do, the bottom line is that they must ensure that they maintain the honor and dignity of the profession. So that is why we have guidelines in the Ghana Bar Association, for instance. They are regulated by the Legal Profession Act. And the Legal Profession Act gave mandate to the General Legal Council to pass regulations to guide the professional conduct of lawyers. We had an old one that was passed as far back as 1969. And after over 50 years, it has now been revised just in 2020. So now we have the new guidelines, which is the Legal Profession, Professional Conduct and Etiquette Rules, 2020 LI 2423, which I would advise all lawyers to get copies at the Assembly Press and read, because it is an expanded version of the repealed legislative instrument. And then the judges also have their code of ethics for judges and magistrates, which I know was revised in 2019 with provisions regarding what judges can and what they cannot do. Social media has come to stay. And it is interesting that the LI, which I just referred you to, defines social media in, okay. I've been advised to remove my mask so that you can hear me loud and clear. Rule 102 of the Legal Profession, Professional Conduct and Etiquette Rules 2020 LI 2423 defines social media as an internet tool that affords the opportunity for a subscriber of the tool to communicate with the contacts, friends, and peers of the subscriber about issues of interest, and may be in the nature of Facebook, LinkedIn, MySpace, WhatsApp, and so on and so forth. Interestingly, although there is a definition provision in LI 2423, the main body of the document has no provision regarding social media. I don't know whether it was an omission or not. There's no provision in the whole of LI 2423 dealing with social media, although I know the original draft had it. I'm sure the president and other people will check this in future. Now, the association, the Code of Conduct of Judges and Magistrates, which was revised in 2019, also had a provision relating to social media, and that defines social media to include communicating or posting information or content of any sort on the internet, including a web log or blog, journal, diary, personal website, social networking, or any affinity website, and includes instant messaging applications or email. And that's what the definition given to the judiciary. Now, I'm taking this topic and people question, why have you been asked to speak on this topic? I just want to let people know, and the truth is that I'm not on any social media platform. I'm not on WhatsApp, I'm not on Instagram, I'm not on the Facebook, I'm not on the, what else? LinkedIn and IG and so on and so forth. When WhatsApp came, I was one of the first people to install WhatsApp on my phone. I deleted it after some time, and for personal reasons, some of these things have worked for me, but when I retire, I'll get back to it. That's when I will enjoy it. So I'm going to speak in general terms because I'm not on social media. but at least I'm on Skype. And then there is a Google Duo. When I want to contact my relatives abroad, I use Skype and I use Google Duo. Is that also social media? If that is also social media, then I'm on some sort of social media that allows me to communicate with people. So that is good. So I'm going to speak in general terms, and Victoria, who is on social media, will come in and deal with the specifics because she's been going on the posts and blogs and other things which people put on it to tell you what is permissible and what is not. It's a fact that social media has revolutionized the world in such a way that it is rare to meet someone who does not use at least one social media platform or the other. The exception is Justice Nene Amegatcher. So I've made that exception for myself. So if people all over the world use social media, then that includes judges, it includes lawyers, and people within the legal community. They all use social media. So law firms, the staff, the lawyers, and many others also use social media in order to share and communicate with others and their clients. So is it proper for lawyers to do that, to use social media, what we know to be social media? Social media has many benefits, which I want us to look at briefly. The sheer number of people who you can communicate with within a short time by the click of the button makes it very attractive. When I remember when we were attending conferences in person, the International Bar Association and the Commonwealth Lawyers Association, you have to carry your complimentary cards as well as your firm profile so that you distribute to your colleagues over there to know where you are coming from and how they can contact you. And with that, you can only give to a limited number of people you meet at such programs. But with social media, with the click of a button, you can distribute this to over hundreds of thousands and even a million of people. And that's why it is very attractive. It also facilitates communication and connection among people who have similar interests, and permits clients who do not want to use emails. They want what we call instant. They press instant, it hits your equipment, and then they expect a reply within the shortest possible time. So because of these advantages, it has been very, very, very attractive to many law firms and lawyers to use social media. There are also challenges in the use of social media, and time will not permit us to go through all the challenges, but Victoria will highlight some of these practical challenges in due course. The challenges posed is to the rule of law and the maintenance of public confidence in the independence and integrity of the judiciary. An example of that challenge is the trend that is developing whereby people vent their frustration and anger. Can imagine somebody appearing in court hoping to win a case or a ruling, and the ruling is delivered against that person. People come out of the courtroom, they get frustrated, they vent their anger, and they make inappropriate attacks against individual judges and as well as the justice delivery system. Specific examples will be provided sooner or later. In the United States, for instance, in Florida, a lawyer went to court, appeared before a judge, in Florida. And at the end of the proceedings, when the lawyer came out of the courtroom and went to his office, this is what he posted on a popular legal blog about the judge. Quote, "Evil, unfair witch." So these things do happen. There's always temptation when you have a clash or you've had a clash with a judge or somebody to vent your anger. And I learned workers also do it when they have challenges with their management, and then they go and post things on their blog to attack the management. So the question is that because of some of these challenges that we have about the use of social media, does it mean that lawyers and judges should not be permitted or should not be allowed to use social media? I do not think that should be the case. Everything that we have in this world or has been created by God in this world, there are right ways and wrong ways to use these things. And we find people using things the wrong way. It does not mean that because of that, somebody is taking alcohol, driving his vehicle, crash the vehicle into a wall or into people. So we should stop driving vehicles. That is not it. There's a right way and a wrong way to do what we have. And that is why it is important for us to discuss it as members of the legal profession. As I said, our profession is very regulated. And the reason why it is regulated is that others may behave in a particular manner, but when you behave in that same manner, you are in trouble with your regulators. Let others beat their partners or hit their partners, and you let a lawyer or a judge assault your partner, and let a report be made to your regulators, and you are in trouble because you belong to a profession in which much is expected. To whom much is given, much is expected. And that is the legal profession. You cannot do anything at all. You cannot sit in your car, drive, park in the middle of the road, and start fighting drivers in the middle of the road. Your conduct will be reported to the disciplinary committee, and you are in trouble. So generally, in the world or in the community, people behave in particular manner or particular way. But that does not mean that you, a member of the legal profession, should also behave in that way. That is why it is necessary, it is important for us to discuss social media and the right and the wrong way and how to control ourselves. Now, the aspect of our professional rules which affect social media is first, confidentiality. Secondly, improper communication. Thirdly, advertising, solicitation, and then the administration of justice. I'll just quickly highlight some of these things. For confidentiality, as lawyers, and this is provided for in the LI 2423 and most of our regulation, we are supposed to keep information and documents that clients give us confidential. That is one of the critical roles that lawyers play. So in our rules, we have lawyer-client confidentiality. The discussion between a lawyer and the client is privileged. In the same way that the media, it said that they are not compelled to disclose the source of their what? Source of their information, how they got their information. You cannot compel a media man to tell you it was A or B who gave the information to you. Lawyers are supposed to keep clients' information confidential. In the era of social media, you may be having discussions with others and a question will be posed to you. You ought to be very careful because it is tempting or very easy for a lawyer to write and say, well, I've dealt with a similar thing before, this and that client, or I represented this client, especially where they are high-profile client. In the US, Victoria sent me a video in which a lawyer had to disclose that he's represented President Trump on a similar issue. So lawyers are to be very careful what clients place before them or discuss with them, not to disclose these things. And then improper communication is one of the greatest challenges on social media. So many things are put on social media, and that's why sometimes there's a third world war erupting on social media, especially when we hear that a news item is gone viral. It means everybody is commenting on it. And people put all sorts of things. Sometimes the communication is so unfortunate, but that's where you have to check yourself. There are certain things you put in there you cannot retract. You can only apologize, but you would have done it already. So you have to be very careful. Improper communication. People may insult others by putting or posting things on their walls, but as a lawyer, are you supposed to follow suit? You ought to be careful about this. Then advertising. In our jurisdiction, advertising is prohibited. In some jurisdictions, like the United States of America, advertising of legal services is permitted. In Ghana, it is not permitted. But Mr. President, for some reasons, I do not know, going through the new LI 2423, the original draft in 2015, which I saw, was a provision relating to advertising and the exceptions where you can market your services. There's a difference between advertising and marketing. That's why you have complimentary cards and you can market your firm in the legal journal and other things. But that is missing in LI 2423. I don't know whether it was due to inadvertence or it was deliberately removed. But advertising for us is very critical. You, the lawyer, you are supposed to advertise yourself by your performance in court and let others judge you and engage your services. So the era of social media is one of the areas that people can abuse and advertise themselves. But you are not supposed to advertise yourself. And if you advertise yourself by posting your pictures in wig and gown on a social media blog or wall, cases that you file on behalf of clients, immediately you prepare the case, you want the whole world to know how good you are and how well you are able to craft your pleadings. So you post it on your wall. You are advertising your services, and you have to be very, very careful about that. Solicitation is trying to win clients through improper method, using all kinds of agents and runners up and placing things in order to solicit for clients. That is also not permitted. But with social media, you can abuse this. And then administration of justice is one of the areas that we ought to focus on. The role of lawyers and judges is such that everything ought to be done in order to protect the administration of justice. And that is why our focus should be what we are putting up there, what I'm placing on my social media wall. Will it help in administration of justice? When you look at the 2019 amended code for judges and magistrates, it says that a judge shall exercise extreme caution when engaging in any type of electronic communication for private or official purposes, particularly A judge shall ensure that his interaction on social media are consistent with the rules and principles contained in this code. That is the code for judges and magistrates. So what are some of the rules and principles that we can briefly look at, especially given the nature of the judicial office? The use of social media by judges raises specific questions that all of us should address. The position, the role that judges play in this particular community. How can we ensure that they are permitted to use social media, but at the same time, it's within the confines, the four walls of the rules and regulations provided for them? The judicial role is a dynamic one, but however, judges need to be insightful in order to protect themselves, to protect their families, and also to protect the integrity of the office which they occupy. In some jurisdictions, Australia, Canada, and other places, the courts have adopted certain social media platforms because they want to communicate with their citizens. They want to communicate with the people in a transparent manner. So they have a social media platform where they put in information that the people will access easily. And that is done within the four walls of their rules and regulations. So there's nothing wrong with it, except that it ought to be regulated properly so that you do not go overboard. The impact of social media can have public perception or can affect public perception of what the justice system is. And that's why we have to be very careful. If by the use of social media, the justice system is perceived in a particular way as being biased or not conforming to the rules which are expected of them, then all of us have cause to worry. Now, the use of social media may lead to situations where judges are seen as being influenced from external sources. So where a judge is on a particular social media platform and a particular discussions are placing over there, which are not too good. Definitely, if you're on that particular platform, the impression being created is that you are being influenced by the kind of things which are being placed over there. That's why you ought even to know the sort of platform that you have to be. The use of social media can also encourage ex parte communication. You know, for judges, ex parte communication is a system whereby a judge communicates with only one of the parties in the absence of the other party. And that is not permitted. That is not permitted. But the use of social media can allow that, and judges have to guard against it. For instance, if your child is in a school and you are part of the PTA or Parent-Teacher Association group, and a party appearing before you may also be on that PTA platform, and certain discussions will be going on, it is easy for the two of you to meet and then start talking. And these things ought to be checked. Social media platform also pose potential threat to the privacy and safety of judges, especially when people know that you are a judge and you're on this particular platform. And they either want to communicate something to you or they want to attack you, like cyberbullying, forwarding certain things or threats on you. You ought to be very careful which platform to choose, whether a social media platform which is public in nature, where you have so many people, thousands, 2,000, 10,000, 1 million. Is it advisable for you as a judge to be on that platform? You have to judge it. The judiciary, their conduct is regulated by the Bangalore principle. And the Bangalore principle talks about first, independence, secondly, impartiality, thirdly, integrity and propriety. So everything, whether a judge is on a social media platform or not, your post, your communication and other things, you have to weigh it against your independence as a judge, your impartiality as a judge, your integrity. You ought to maintain and safeguard your integrity, as well as whether what you are posting is proper, whether it will enhance your reputation as a judge or not. That's what we call propriety. Now, I want to give some tips for using social media by lawyers and judges. Some tips for the use of social media by lawyers and judges. First, I'll say lawyers and judges should think twice before posting anything on social media platform. Avoid posting information that can be interpreted either as you are giving legal advice to thousands of people on a platform, or you want to publicize yourself, you want to advertise yourself. The men's right, the intention is critical. Many lawyers put things on social media, not because they either want to educate the public or they just want to contribute to an emerging debate, but they are doing it to project themselves. If the aim and the reason for doing that is to project yourself, then think twice, pause, and think twice. You'll be going contrary to the rules, or you'll be going overboard. Be mindful of the platform where you share your capabilities. And this is true for both judges and lawyers. Thirdly, be mindful of what you post on the various platforms. Lawyers are permitted, as I said, in Ghana, to market their services on any media platform. They are not permitted to advertise their services. So be careful what you post. Let me give you one or two examples. For instance, posting on your page, your social media page or wall, about a great victory that you've won in court will be problematic. One example that a lawyer posted in the United States of America, which I got in my research, is after he left court and after judgment was delivered in his favor, he went on his page and posted this, and I quote, "Another great victory in court today. My client is delighted. Who wants to be next?" Is it marketing or advertising yourself? You are definitely advertising yourself. Then another one. We won $1 million verdict today. Tell your friends to check out my website. So, as a lawyer, you ought to be very careful. You must know the distinction and the difference between advertising and marketing and what to post on your wall. Lawyers and judges conducting on social media, especially, since they may run in the same circles. The third one is whether lawyers and judges should be permitted to connect and be social media friends. That has been a very big debate. It has been a very big be it because people may have known each other from school, and so there's nothing wrong in they connecting. In any case, I don't intend to appear before this judge, or I may not appear before this judge, or this judge is sitting in Koforidua and not Accra, and I practice from Accra, so I would not. But you don't know when your case may be placed before that judge. If you're on the same platform with that judge as social media friends. I know that a place like the Ghana Bar Association, for instance, has a platform, and that is for lawyers. And I know the Association of Judges and Magistrates, they also have their platform where they place things. But at the same time, it is possible that your year group will have a platform, and you are a judge, and then you have other colleagues who are lawyers who are also on the same platform. And I remember before I left Okudzeto and Associates for the bench, they had a platform, although I was not on the platform. But if I were on that particular platform at that time, after migrating to the bench, I could not continue to be friends with people like Victoria and others on that platform. Although, to reveal a secret, I'm told that Okudzeto and Associates are operating two platforms. The reason why they're operating two platforms is that there's one platform with veteran Okudzeto on it. And the younger ones who came protested that they will not be free to express certain things that they want to. So they should set up a second platform without Okudzeto on, so that they'll be free to express themselves. But then you have to be very careful what you put in there, because you know Okudzeto will check you on the other one. So that is the temptation about that. So lawyers and judges should also be careful not to post comments that could be construed as advancing their personal interests. I've talked about that already. And then there should be no relationship with persons or organizations that may convey an impression that these persons or organizations are in a position to influence the judge. So again, where you choose to post or those you choose to make friends with on social media, then you must be very careful, even where you are on social media, not to post anything that for you, a lawyer, that you've been engaged in as a lawyer, or those that you are working as a judge, a case that is before you, where there is discussion on a particular platform, especially cases of national interest. There's always the temptation to know, I know it because I'm currently handling a similar or an aspect of that case. You have to be very careful. You'll be going overboard. Then judges also should be very careful not to view the social media pages of parties and witnesses. This it's happened in some jurisdictions before, which judges go into some social media pages and blogs, and it's witnesses testifying before them or parties before them. They ought to be very careful about that. Judges also should be careful not to give legal advice. It's one temptation we face. Since I became a judge, I've had countless requests from people asking me for legal advice. Despite the fact that I push them to go and see their lawyers, they keep on coming. So because people know that you're a judge, they will always be coming to you for legal advice. And sometimes it may end up giving advice on social media. There should be no political activities on social networking sites. There's always the temptation when, especially during an election year or so, when discussions are going ought to be very careful, or when, especially when of the things that some senior judges put on the Association of Judges and Judiciaries platform is something to write home about. Very disappointing. But as judges and lawyers, you are trained to control yourself. Can you imagine what happened in this country on the 7th of January when the parliament was in session? We were all shocked. People were shocked what they saw in over there. But that is ended to the abbey so low, some banging tables and screaming and shouting. Lawyers of that particular caliber, it is not expected that lawyers should stoop so low. Much is expected of you. That is why we have to discuss these issues and know what is expected of members of the legal profession and what one cannot do. I'm just about to wind up what I'm supposed to do right now. There is, I copied, what do you call it? The rules about social media on the association of that will allow me to read some of these things. Once it is on the, it is in the end, advise themselves. But let me conclude by saying that the use of social media as an essential part of our daily life cannot be ignored these days. It is a fact of life. It has come to stay. We cannot run away from it. But however, is to carve out rules and regulations that will control its use, so that it has come to stay. The role of lawyers and judges is to use it in a positive vein in order to promote the activities of the legal profession and use of social media by any other colleagues that will bring the administration of justice into disrepute, and that will allow members of the public.
Thank you for opportunity and privilege. I always get to share the same platform as the man who taught me, raised me in the law, and even introduced me to the subject of ethics and the teaching of it. So it's a real honor and pleasure, not just to address the bench, the bar, and faculty, but also to share this platform with him. Having said that, that was a breach of confidence regarding some Okudzeto and Associates platform. Now, His Lordship has covered a substantial aspect of matters relating to how lawyers use social media or may use social media tools in our practice. And so we'll run through some of the slides and deal with the meat as far as the line 2423 is concerned, and how it impacts on some of the areas of risk and likely breach, to look at all governing legal ethics in this jurisdiction, key duties that must be observed by lawyers in using social media. While we do that, we'll discuss some sample posts to see how adequately the law addresses some of the challenges presented with lawyers' use of social media. And I will conclude with a few thoughts on perhaps some changes or considerations that must be taken into account. So His Lordship has already referred to the Legal Profession Act. Sections 23 and 53 of that act provide for the making of rules by legislative instruments by the General Legal Counsel to prescribe standards for how we conduct ourselves as legal professionals. And that gave birth to LI 613, which has been revoked and as of 9/3 came into force. Now, if you have nothing to do with the business of ethics on a daily basis, I don't blame you if you're not aware of that, but please, it's not that bulky. Get a copy. Case law has also been part of how our conduct as lawyers and our ethical duties have been regulated. Unfortunately, when it comes to the use of social media, you find that you have to look beyond Ghana, because the only case of specific relevance that I may allude to is the case of Mr. Francis Javier Susu, and we'll get to that. Then, of course, we have the controversial Ghana Bar Association Code of Ethics, and I say controversial because for those of you who followed yesterday's proceedings, the point was made emphatically that the GBA is a voluntary association. And if that is the case, what is the binding force of the code of ethics of that association? Is it only binding on its members? It's not also born out of Act 32 specifically, but I'll leave that controversy for another day if you give me the opportunity to address you once again. Now, the definition of social media, I will not belabor because His Lordship has covered that, except to say, pay attention to words like contacts, friends, and peers, and especially friends, because for those who know the workings of Facebook and Twitter and the like, and I kid you not, I mean, he says, I am going to tell you about social media. I'm only on Facebook and WhatsApp. And Facebook, my gateway to Facebook on a daily basis is Mr. Isana Nankoma, because I don't remember my password. But when he pops up in my email, because he's a regular, if I may call him, poster, I view the post and I enter Facebook. I like a few things. I comment here and there. But having to handle this topic has taught me the importance of knowing the pitfalls of using those platforms. And I must say that a number of young people in the firm have been very resourceful. So again, the characteristics, I mean, it has speed, gives you access to a wide audience beyond the borders of your area of practice. Senior, you're welcome. I just acknowledge you as my gateway to Facebook on a daily basis. So again, you will have access to the slides. Looking at the time that we may have for questions, I will not stay too long on this slide. Please move on. Same with benefits and drawbacks or cons. Please move on. Again, His Lordship has addressed the impact of social media. So now let's get to the key duties. Next slide, please. So he talked about confidentiality. And this is what LI 2423 provides, that a lawyer shall not reveal information relating to the representation of a client unless A, the client consents to the disclosure, B, the disclosure is necessary in order to carry out the representation, or C, the disclosure is permitted under the rules or any other law. So before you post any information at all that concerns the representation of your client on any social media platform, you have to ask yourself, is this a necessary disclosure for the conduct or the carrying out of my representation? Is it permitted by the rules? What is the motive for posting pleadings that you have drafted on social media? Is it for the public to determine how good a drafter you are or how bad you are at drafting? What is the public interest element in that thing that you have filed in court? What sort of comments are you likely to invite which may prejudge the outcome of that matter or ridicule even the parties to that pleading? I mean, we see people posting pleadings in divorce matters. So far, we've not been able to attribute them to lawyers because divorce proceedings in particular are usually even supposed to be handled in camera. And what business of anybody's is it if somebody has acquired so much property within a space of however many years of marrying someone? I don't need to know that. It's between the two of them. So again, the client consenting. What kind of conversation exactly did you have with the client before posting pictures of them on your page? Maybe you came out of court, they've thrown some white powder on you, presumably you've won a case, and then you post it with a client. That client needs to give informed consent. And informed consent usually presupposes that an independent lawyer has advised that person of the consequences of what you are posting. What is the interest of that client in that image that you are putting up? Is it to project yourself and your practice, or is it really in the best interest of your client? For all we know, you took default judgment, and it's a big victory. Misleading the public about the victory you just won because the other party chose not to show up. Next slide, please. Conflict of interest. There are so many things in the rules about conflict of interest, but this was the only one that was remotely linked to the subject of social media. And it comes back again to the point that His Lordship made about the fact that besides the definition of social media in Rule 102 of LI 2423, there's no specific provision. But again, for those who know the workings of social media, and I'm afraid I will not have the time to go into the technicalities of it, which I'm grateful for, I won't lie to you. But what can happen is that you can friend somebody whose interest is adverse to that of your client without realizing it. You may even proffer an opinion on a matter that they put up on social media, which may adversely affect the interests of an existing client. And you really have no control sometimes over the people who even have access to your page. Because a friend of yours may open your post in a group that they belong to and they expose you to the people on there. See, that's one of the things I learned recently. So through inadvertence, you may breach your duty not to represent conflicting interests or to act in the best interest of your client. Next slide, please. Then we have advertising and touting, whether by coincidence or design. The provision on advertising and touting, which was in LI 613, has been completely omitted from LI 2423. Whether that gives us license to advertise in an unrestrained manner on social media or elsewhere, I have my doubts, because we are in the era of purposive interpretation. So I still refer to this case because, like I said, it is the only one that is available and of direct application to breaches of ethics resulting from the use of social media. And even though it relates to rules which currently do not form part of the current LI, it is still relevant. What happened in that case? And note, I'm aware that it is on appeal, but the aspect that I'm referring to has nothing to do with the merits of the appeal. I'm looking at what the facts, at least as far as the High Court has determined, consist of. What was the charge? Rule 24 of now revoked LI 613, was the charge against Mr. Susu, and he was alleged to have, while acting as counsel for Togbe Afede, do the Roman numeral, in a matter between Togbe and the Chief of Defense Staff, to Facebook with pictures of the parties and made comments on the case to the public with his firm's name, address, and telephone numbers attached, with the primary motive of personal advertisement and touting. Now, according to the facts, he's said to have pleaded guilty, and so we do not have the benefit of what the reasoning of the disciplinary committee would have been if they had actually had to apply the rule to the facts and come out with some reasoned decision. But the point is, you even find some links between the new rule on confidentiality and this kind of posting. Was Togbe Afede aware that those things were going to be posted, and the other persons whose name appear in the pleadings? Is it okay to put a matter that I'm involved in, the pleadings of that matter, on social media, simply because when a matter is filed in court, it is deemed to be in the public domain? I recently had a rude shock when I applied for proceedings in a matter because, in my view, the outcome of that decision was going to affect my client's fortunes in another matter. And the registrar told me that it is only public after judgment has been given, that is a directive that he has received. This was a registrar, I think, in the land court in Tema. I found it intriguing. But I can begin to appreciate why in some cases, perhaps those that are heard in camera, why, obviously, I mean, it will even be difficult asking for proceedings in a divorce matter. But land, I had my doubts, but they know the sort of things that people are able to do with processes that are filed while the matters are pending. So again, the same questions. What is the public interest aspect of a lawyer's personal professional practice such that these things must be put up? Why is your telephone number up there? Who needs to call you in relation to the pleadings that you have put up? You know, what is the impact on the firm itself? Because this is one lawyer in the firm doing that. Now, as we go through the rules, you will see that now you can be held responsible for the conduct of your subordinates and your support staff, where you ought to have made sure that, you know, there were rules or policies or guidelines in place so that they adhere to the duties that you owe to your clients, the profession, the public, and the court. So, solicitation. Now, Rule 1 says a lawyer or a law firm shall not personally or through other means of communication solicit for professional employment from a prospective client where the motive for the solicitation is the pecuniary gain of the lawyer or the law firm, unless the person contacted is a lawyer or has a family, personal, or prior professional relationship with the lawyer or the law firm. I have a slight problem with this provision. In the old law, there was no reference to the person contacted. In my humble view, it gives the impression that solicitation is targeted at an identifiable specific individual or entity. Is that going to bite when I put it, you know, at large on social media? Am I contacting someone specifically? So I don't know. That is my view. Some of these things, if we are thinking of social media, then we may want to make the rule wide enough so that there's no doubt whatsoever in my mind when I look at it, that it's not limited to when I'm targeting an identifiable individual. That same rule then talks about creation of websites. Hitherto, it was in the guidelines of the General Legal Counsel. Now it's been incorporated in the LI. And of course, somebody tells me website is digital, it's not part of social media. But sub-rule 8 of rule 15 itself expressly says that these websites do not include social media. So there's an express exclusion of social media. And so the content that can be found on your website, you cannot go and put it on social media. And I believe LinkedIn has been defined as a social media tool. So that raises interesting questions that one may have when there's an extended period for discussion. I'm missing one slide on the rules 6, 7, and 8 on solicitation, sub rule 6, 7. But I'll read it for you here. The 8 is the one that says for the purposes of this rule, the website of a lawyer or a law firm does not include social media. But 7 says a lawyer or the head of a law firm shall not publish on the website of that lawyer or the head of the law firm a description of the lawyer or the law firm that includes language that implies or connotes that the lawyer or the law firm is the best lawyer or law firm or has a high level of expertise. You know, we do these things on radio, legal luminary, expert, you know, but please, it's not allowed on your website. And talk less of social media. And then again, you shall also not publish on the website of the lawyer or the head of the law firm a statement that is inaccurate or likely to mislead the public, 2, diminish public confidence in the legal profession and the administration of justice, or otherwise bring the legal profession into disrepute. C, a criticism of another lawyer or law firm. Sometimes by hyping yourself, you denigrate others. A statement about the success rate of that lawyer or law firm, a statement that is obtrusive and that may cause annoyance to the person to whom the statement is directed. So when you're having these websites built, you have to take these things into consideration. In the same manner, when you are posting on LinkedIn or wherever and talking about clients that you have represented, your choice of language is very key. And be mindful of your duty of confidentiality. Not every client wants it out there that you have represented them in a tax matter. You know, they have an image to protect. Just because you go to court and you deal with my land issues doesn't mean that I want the whole world to know that I was involved in a land litigation or the size or the value of the claim. Because for us lawyers, that is what makes us prominent. Oh, it was $1 billion claim. The principles may have been the same for a 5,000 CD suit, but because of the big ticket size transaction, you know, people must know. I saw a post, and I'm not that person's friend, but it shows you how exposed you are, of 2 lawyers fully robed in gown and everything, I believe on the car park of the court or elsewhere. And this is how they were going. This is the winning team. And I ask myself, if I can't say I'm the winning team on my website, can I say it elsewhere? If they were not in the wig and the gown and the wing color of the bib, perhaps, who cares? But there's a connection between that statement and somebody will say, oh, but it doesn't mean anything. Who knows what they've done to be the winning team? But what is the motive? And how far will you take it next time? So let's watch these things. So you can take your time and look at the rule on solicitation, which also deals with the guidelines for websites. Please move on. Operator, is that a problem? Thank you. It gets interesting from here on. Conduct prejudicial to the administration of justice. That seems to be the minefield for everyone with, I would say, itching lips, not fingers. And Rule 61 provides a lawyer shall not engage in conduct, whether in the course of practice or otherwise. And I like this rule because or otherwise means that I don't have to be the specific lawyer handling the matter in question or representing a client. But depending on the circumstances in which I infringe this rule, it may bite me. And so even though it's not specifically targeted at social media, it is wide enough to bite those who breach this particular rule. So you shall not engage in conduct, whether in the course of practice or otherwise, which is dishonest, calculated, or likely to a material degree to be prejudicial to the administration of justice, diminish public confidence in the administration of justice, or adversely prejudice the ability of you, the lawyer, to practice in accordance with these rules. Again, Rule 89, I'm going to take us through them and then we'll look at some posts, bearing in mind the content of these rules, and you'll be the judge. A lawyer commits professional misconduct where the lawyer violates the rules of professional conduct, obviously, or knowingly assists or induces another lawyer to do so. Engages in conduct which involves dishonesty, fraud, deceit, or misrepresentation. Engages in a conduct that is prejudicial to the administration of justice, or states or implies an ability to improperly influence government agency or official to achieve results by means that violate the rules of professional conduct or other law. Now, there are other rules that I did not focus on because they were of direct application to specific lawyers handling pending proceedings and so forth. But I picked these ones because they are of a broad application. Then Rule 55, you may recall during the election petition hearing that the Lord Chief Justice had cause to refer to this rule, and another one that follows in the next slide, when he called on lawyers representing the various parties to desist from making out-of-court statements relating to the pending proceedings. 55(1) is relevant for other purposes, but 2 is our focus here. A lawyer shall not publish or cause to be published a material concerning current or potential proceedings, and my emphasis is on the word including proceedings for which the lawyer is engaged or seeks to be engaged. I emphasize on the word including because it means it's not just limited to that, to proceedings in which you may be engaged or for which you seek to be engaged. It could be in relation to current or potential proceedings in respect of which you have not been engaged or you are not seeking to be engaged. And it says, you shall not publish or cause to be published material concerning those proceedings, which is inaccurate or has received comment or unnecessary description, which identifies you, the lawyer, as a lawyer and appears to express an opinion of the lawyer on a matter relevant to the case, other than in an article or case note in a publication circulated primarily to other lawyers or legal academicians, or is calculated or is likely to a material degree to diminish or be prejudicial to the public confidence in the administration of justice. I will come back and digest these more when we look at the examples, but I believe you can see the reason why if a lawyer is expressing an opinion on current or potential proceedings, it makes sense that it is done on a platform where other lawyers who can appreciate those comments in their proper context will be the ones who have access and not the general public. Rule 38 is the other rule that the Lord Chief Justice referred to, and it has to do with commenting on pending matters. And again, this is one of the rules that appears to be directly applicable to the particular lawyer involved in the matter and not other lawyers. We may want to look at it. A lawyer who is participating or has participated in the investigation or litigation of a matter, I think I missed investigation before. That one also may have a wider reach if you are not even the one announcing yourself or appearing, but you've participated in the investigation or litigation of a matter that is still pending before a court, shall not make an out-of-court statement or grant an interview to the media on the matter. So the remaining points on that slide are not part of Rule 38. They are just cautionary notes about the fact that when you take these rules into consideration, you should understand how the sites where you make your comments or you publish material operate and how that information can be shared beyond your intended audience, and also the use of private settings. So now let's go to the interesting part. Yes, next slide. Disclaimer and disclosure. I believe it's no secret that I played some part in the representation of the President of the Republic of Ghana. You didn't see me in court, but I played a minor role, and I say this in humility, but I need to put it out there because I'm going to deal with material that comes out of that case. And I know we are humans. There will be the perception that I've targeted lawyers and individuals of the opposing, of the petitioner's leanings who have made posts. That was not my intention. I had the prerogative to choose, fortunately, as a presenter, and these ones caught my attention and have significant relevance, having regard to the fact that I don't think that we've had so much posting on social media regarding any matter in the recent past than the election petitions. It's a perfect example. And again, in case you didn't know, once you post, you give me the license. So here I am, I'm sharing. This is Mr. Sami Demfi, and if you didn't know he was a lawyer, I believe his apparel will confirm that for you. He's born of success and sponsored by grace. Now, we are going to look at the rules, but I also want you to see how much information people can pick up. I mean, I had a little help in pulling these things up, but if I really knew how to dig and see more information, I'll show you more, and I don't have the time. And Mr. Semidemfi, if you are watching, no hard feelings. This is just a learning experience. He has 96.8 thousand followers. You see that circled on the top left corner. And the thing about social media is that you end up being an influencer sometimes without realizing. In fact, it was one of the reasons why I selected this particular individual's post. Mr. Ankoma, I'll be coming to you shortly. I'm just giving you notice. So he follows 187 others, but he has over 96,000 followers. Okay. Now you see the circle red down there with 228,313,2K. Good. So that's interpreted on the face of the cartoon or effigy, if you may call it. He has 2,000 likes. That's the heart shape with the two. Oh, please go back. You don't like the picture? Ah, thank you. So the heart shape with 2K, that means 2,000 people liked this image when it was posted and whatever the caption was. 228 people commented. 313 people retweeted, shared it. Now you can imagine how many followers those 313 people have and the impact that this message has. Now, what did he say? Why is Jean Mensah running away from cross-examination? Why is she trying to escape from accountability and a credibility test if she discharged her duties as returning officer of the 2020 presidential election truthfully and legally? Oh, what a shame. Hashtag she must enter the box. Now, I believe if we check, this was February 9th, and I wish I had checked the proceedings, but I'm almost certain that the Supreme Court was yet to rule on whether or not Mrs. Jean Mensah could be compelled to enter the witness box. What does this do for the over 96,000 people plus the retweeters and the sharers and the friends who look at it, coming from a lawyer? First of all, look at the way Jean Mensah is depicted in the image. If I can't ridicule a client in open court, can I portray them in a manner of this nature? Look at Mr. Akotampo. I'm pretty certain that's not Mr. Amenuvor. On his knees. My Lord, please intervene. Stop this cross-examination. The one that got me was the song. Odiboyeni running away, nobody tired. I think it's KK Kabobu. And the lordships are sitting there. So on so many levels, I wish we could roll the rules along this. Hashtag she must enter the box. Is that a conclusive determination of how the court must rule on whether or not she must enter the box? Was Jean Mensah a party on trial, or was she the representative of an entity? If you look at why is she escaping from accountability? Yes, I don't divorce her from the fact that as chairperson of the EC, she's somehow inextricably linked to the activities of the EC. But as lawyers, when we are posting these things, do we think of the implications for the issues in controversy to be determined and how we condition the minds of people in the public to receive the ruling of the court when it goes contrary to what we advocate? Next slide. Another one. This got 1,632 likes. And you know, sometimes we don't have to be the people who post. Are we equally guilty when we like or we retweet? I leave that question for you to answer. The purpose of Dr. Kpesa White's evidence was to demonstrate the bad faith, lack of candor, and due process displayed by Jean Mensah in the collation and declaration of results in violation of Articles 23 and 296 of the 1992 Constitution. And he did that brilliantly. This is evidence that is yet to be analyzed by a court of law. And I'm fairly certain that there was an issue in the memorandum of issues regarding Articles 23 and 296, because I remember the Lord Chief Justice ruling touching on those. But look at the content of the post. It has pronounced judgment as far as the violation of those articles are concerned. So when the court now reads its judgment and says the evidence of Dr. Kpesa White and Mr. Robert Joseph Metil-Nunu essentially have no consequence, and the least said about it, the better. What have you done by posting this before? Next slide. So when we're posting, we need to ask ourselves, what are the issues for trial? And now this one is Roxanne Nelson, the Fiamako Esquire MP, legal analyst, consummate lawmaker. I love this one, family papa, social democrat, papa, politician. I think he means he's a family man, and we love family men. Man U fan. Now, you see, in fact, sometimes the comments that come with the tweets are even more interesting. But let's start with what he posted, which is in quotation marks, and I believe is being ascribed to His Excellency, the former President, John Dramani Mahama. The EC, aided by the Supreme Court, evaded accountability to the people of Ghana. The Supreme Court aided the EC to evade accountability. What's the primary duty of a court that sits to dispense justice? And when you say this categorically, I don't care about the originator of the statement. He says he's a consummate lawmaker, he's an MP, he's an Esquire. Esquire can simply mean Mr., but in our part of the world, there's no dispute about the fact that when people put Esquire after their names, they want to tell you that they are a lawyer. And he's in Parliament. And I don't even want to go on the parliamentarian tangent, but as a lawyer who has a duty not to diminish the public's confidence in the administration of justice, when you post this, or you tag it, or you like it, or you retweet it, what kind of message are you sending to the public? That the apex court is in the business of aiding people to evade accountability. Forget about the facts and the basis. 235 likes, 22 retweets. And then, don't you just love the English on Facebook? With the greatest respect, you people also betrayed the over 6 million people. No, that's not the mechanic, the word in front of his name, the PU, I can't mention that one, sorry. But he says, Esquire, do one seeks accountability at the Supreme Court? Politics blindness. Someone says, no, we seek accountability in the farm. Jimmy questions say, you know, you get a kick out of, my time is up. I'm winding up, yes. I'm winding up. Oh gosh, it flew. So you get the picture. You go back and you look at Rule 61, 89. So now, next slide. There you are, Senior. What is the difference between the tea without biscuits, as in tea Sakura saying, touch not my biscuits and do my tea no harm. Add the next one because they're on the same tangent, please. Oh, Nipa, you're bad. You didn't even call KW to come and try the tea song. Who corroborates the without biscuits story? What is the difference between the posts that I showed? For those of us who know, we know that this tea and biscuits issue relates to the same election petition hearing. But this is more of a social commentary. I tried to pull your profile. I had a little difficulty, but I know that at least on Twitter, you have over 20,000 followers. As for Facebook, I'm one of your followers. Please don't sack me, because I learn a lot there. But I'm just saying, there are ways you can post for humor. Does this diminish public confidence in the judiciary or the administration of justice? Does it, cast aspersions on anyone anyway? So, last one, and then I will leave. And this one says, the law, this is Togbe Kakakofi II. I think his real name is Jerry John something. He's also a lawyer. Again, I'm missing the slide that shows his profile. But I think he went to school, he's from class of 2016, Ghana School of Law. I looked that up, so I know that he's a lawyer. The law you quoted says, at any stage of proceedings, ... ellipsis, but you submit that because the party closed their case, it is not applicable to them, exclamation mark. Has judgment been given in the matter? Proceedings are not still ongoing. What kind of voodoo interpretation is that? I'm pretty sure that's not how voodoo is spelled. And someone says, a deliberate burning our bone. And voodoo interpretation, that part made me faint. So you recall that one of the rules says, when you misrepresent, I will try and go back to it, but which provision is this person talking about? First of all, he doesn't put the full provision. He picks a bit of it as if it's a blanket statement that at any stage of proceedings, a party can have the court summon a witness for them to cross-examine. The provision is section 58. For people like me who were following the case or had something to do with it, I'm able to tell what the person is talking about. And you see that that provision says subject to any enactment or rule of law. One of the enactments is the Evidence Act, section 72, which provides that certain things that may be done can only be done while a party is still presenting evidence. And so when a court says you have closed your case, you did not make this application at a time when you were still presenting evidence. So satisfy me first that you are entitled to reopen your case. Then we can look at summoning a witness. Again, you may see that through a biased lens because I had something to do with the second respondent's case. You're entitled to that. I've made that disclosure, I've put it out there. But as lawyers, we have a duty not to misrepresent facts, to misrepresent the law, to misrepresent proceedings. Let other people do that. But let's not do this. And at the time they were doing this, LI 2423 had come into force. So the next slide just tells you about how long we have taken to make changes in our laws on ethics and the need to make constant amendments, if you may put it that way, because change is always happening. Advances in technology may require that we catch up, and then other risk areas that we may want to consider in the event of some amendments coming up. So until next time, think before you post, see who your friends are, and I'll be watching. Thank you.
Thank you very much, Victoria. Thank you very much, Your Lordship. Your Lordship, Victoria, there are just 3 questions of moment. 1, is it unethical for a lawyer or a judge to be fully robed and put that picture on his DP or status or page? The second question, Does the regulation not stifle the freedom of expression and the public education that lawyers are supposed to do? Third question, if I publish a legal article in a newspaper and I add my name and telephone number, will it amount to advertising and touting? I'm wondering how the person can, manage the volume of phone calls that will come back. That is for you in any order to answer, my Lord and Victoria. These are just 3 questions and then we are done.
The first question, putting your picture fully robed, wig and gown on your blog or your Facebook wall, that is advertising. That's advertising because the wig and gown is only worn when you are in court. You are not supposed to wear it outside court. So what is the purpose? What is the rationale in putting the wig and gown on your Facebook wall? You are advertising yourself. You are projecting yourself. Then it is as simple as that. There's no compromise. Victoria will take the second and the third question.
Second question about stifling freedom of expression. Every freedom that we have has boundaries, and especially as lawyers, we can't comment unrestrained like the lay person. So no one is limiting your freedom of expression. All we are saying is that you are governed by rules of ethics. Make sure that what you are communicating does not infringe those rules. And when you take your time and you look at those rules, you see that there's a reason why they have been put there in the first place, so that we do not undermine the administration of justice. And then about education, again, like I said, we didn't have enough time. I would have shared Mr. Nkome's post. He had one yesterday on adverse possession. You know, he had seen a video going around, somebody saying that when you take possession of another's property for 10 years, then you could become an adverse possessor. And he shed some light on what it takes to become an adverse possessor. Nothing against educating the public in that manner. The only thing is, depending on how you do it, and if you don't know how to do, you may want to put a disclaimer that this is not supposed to constitute any legal relationship, lawyer-client relationship between you and those who come on there. But when I looked at the comments, his followers fully appreciated that this was free learning, given the fact that something was going around which was misleading the public. So there are a lot of people who educate us, lawyers who educate us on social media, and there's nothing against that. Gosh, I've forgotten the third question. What is the purpose of the phone number? Oh, sorry. I mean, your name, fine, is to say who the author of the publication is. Unless it's supposed to be anonymous, we expect to know who authored it. But your phone number, who needs to call you? I mean, is there a further explanation that you need to give? The editor knows who you are. Who needs your number for anything? It's not necessary. Further and better, no, not in my humble view. Thank you very much.
Your Lordship and Victoria, thank you so very much. I believe that we have learned a lot and will still continue learning. Without much ado, may I invite Dr. Kwekwenison, Justice Ellen Vivia Amwa, and Ace Ananankoma to take over for the next session.